CF 314, the appearances are the same. The record should reflect the jury is not in the courtroom. With that, which attorney wishes to put something on the record?
That would be me, Your Honor. I will indicate that defense counsel Jeremy Perry and I have been discussing the interview transcript, and the state has told defense counsel which portions of the interview we intend to play, and we've got the transcripts of those intervals also. Now, it's my understanding that defense counsel Jeremy Perry intends to cross-examine Paul Ratzberg about things that were not within those transcript clips. In other words, he wants to cross-examine Detective and Lieutenant Ratzberg about statements that Lieutenant Ratzberg made elsewhere in the interview. And the state's objection is that it's hearsay. And the defense argument is that it becomes relevant because their position is that Aaron Dillard had an opportunity to read this entire transcript. And so therefore, Aaron Dillard's statement about what Mark Jensen allegedly told him was informed not by what Mark Jensen told him, but by what Aaron Dillard read in the transcript of the interview. So it's sort of a conditional relevance. The condition precedent is that they need to establish or show that Aaron Dillard read this interview transcript. So I don't have a problem with them being able to cross-examine Detective Ratzberg eventually about the statements that are contained in the interview transcript, assuming they meet that condition precedent. But however, I don't think they can meet that condition precedent. I don't think they will be able to meet that condition precedent. So I don't think they should be allowed to cross-examine Detective Ratzberg about his statements in the interview until they've established that conditional precedent to wit that Aaron Dillard had read or had an opportunity to read this transcript.
What exactly does the defense want to cross this lieutenant about that is objectionable by the state?
It's nothing. I'll be very specific. It's nothing new. This all came in 2008, and the last thing that Mr. Jamboys just said is that to show that Aaron Dillard had an opportunity to view this transcript, and we're going to establish in this trial that this. That there was a transcript. Obviously, there was a transcript of this interview prepared. It's going to come up in mere moments. That transcript was sent to Mark Jensen 4 days before Aaron Dillard got to the Kenosha jail. And what I'm going to be asking this declarant about are statements that he made in it. I'm not going to be asking for Mark Jensen's responses, and it's precisely the information that Aaron Dillard then parrots in terms of claiming that Mark Jensen told him. Now, the state in its opening statement said the only way Aaron Dillard could do that is if he heard it from the mouth of Mark Jensen. And we have to have an opportunity to show that there's another way for that statement to have come into Aaron Dillard's possession, and this is that direct way.
But you're not going to ask this witness that this is what Aaron Dillard said.
Yeah. I'm not going to ask him what Aaron Dillard said. I'm going to ask him a handful of statements that he made to Mark Jensen in the interrogation. I'm not going to ask for Mark Jensen's responses. That's it.
I think he can ask what he said.
Here's the problem, Your Honor. First of all, I certainly agree that he can cross-examine Paul Ratzberg, and cross-examination in the state of Wisconsin is wide open. He's not restricted to what I ask about on direct. However, in order for him to cross-examine, he's got to cross-examine him on a relevant proposition. It's got to be something that's relevant. The fact that Detective Ratzberg, for example, at some point was talking about asphyxiation, which I think he was in the course of this interview, that's not relevant unless they can show it's relevant. And their argument for relevance is that Aaron Dillard saw that or read that, but they can't show that Aaron Dillard read that or saw that. And it is true this came out in the last trial, but I've had an opportunity to read the entire transcript of the last trial, And there was simply no evidence that Aaron Dillard ever saw this interview transcript. None. So in order for it to become relevant, they'd have to ask the jury to speculate that Aaron Dillard read this portion or read this interview transcript. There's simply no evidence in the record of the last trial that Aaron Dillard ever saw this. And Aaron Dillard will categorically deny that he saw this. Now, I acknowledge Aaron Dillard. They're going to challenge his credibility, and rightfully so. There's a lot of questions about his credibility. But he's denied that he ever saw it, and they don't have any evidence that he ever did. Now, if they want to put Mark Jensen on the stand, Mark Jensen can testify that, yeah, I showed this to Aaron Dillard. Then they'd have some evidence that Aaron Dillard read this. But right now, and at the last trial, they never presented evidence that Aaron Dillard ever read this transcript. That's so my objection is that the cross-examination on what the detective said elsewhere in the interview is not relevant.
Well, one thing I want to be clear, the defendant does not have to testify. We're not going to get into that. He has an absolute right not to testify.
Oh, I agree. And I certainly didn't. That's why I certainly wanted to say this in front of the jury. I'm just saying that the only evidence that they could present that would show that Aaron Dillard actually read this transcript is if it was Mark Jensen, because there were only two people in the cell at the time when Aaron Dillard was reading the stuff. Aaron Dillard will testify as to what he was reading, and he'll testify he was reading the transcript of Ed Klug's testimony from the forfeiture hearing.
Well, let me ask this question. You said, I thought you were going to play the whole interview.
No, that would be over 4 hours.
All right. So you're going to play 45 minutes of it.
Yes,
right?
we're just going to play. There's a variety of sections of it that we're going to play.
So I'll go back to the defense. Exactly what are you going to ask this lieutenant? Is it about statements he made outside of the interview?
No, outside of the 45 minutes that are going to be played, but part of the interview. I mean, I'll just tell you, it's 1, 2, 3, 4. It's 5 statements that he made.
Give me the 5 statements as an offer of proof.
Okay.
By the way, Your Honor, for the record, the state will stipulate that he made those statements. We've got them on video. And
I think they still have the right, even if you stipulate, they still have the right to ask the
they
question.
don't have the right to ask the question unless it's relevant, and they've got to show its relevance.
I'd say this. The state made this relevant in their opening statement by saying that Aaron Dillard, there's no other place he could have gotten this information. And we will show, and we'll have to show, otherwise we won't have an argument, a closing argument on this. We'll have to show that Aaron Dillard had an opportunity to get this information from someone other than Mark Jensen.
I'm gonna let it in, just to be safe. I've been tough on the defense for relevance, and I think the last time I said it goes to the weight, and if it's 5 questions, what this witness said in the interview, I think it's an appropriate area to get into. So let's bring the jury back, and we will continue.